The next step is for our government, including me, to review the decision, reflect on it. But if the parties seek leave to appeal and it is granted, it would become by definition a question of national importance. On matters of national importance, I and our government firmly believe that the government of Canada has a role to play, particularly in a context where we are dealing with important charter rights like the rights of freedom of religion and equality rights.
With the Bill 21, I think we have a consensus. I think it's a balanced law. Some people would have liked that we go further. Some think that we went too far. But I think if we compare ourselves, for example, with France, I think it's a very reasonable law. And I want to protect this consensus in Quebec.
Quebec's appeal court has upheld the province's controversial secularism law, known as Bill 21. The law was first passed in 2019 and prevents public sector workers from wearing religious symbols on the job. The Quebec government used the notwithstanding clause to pass it, which is part of the Charter of Rights and Freedoms that gives parliaments or legislatures the power to override parts of the charter for 5 years. That move sparked criticism, and civil liberties groups have long called the bill discriminatory. The Fed signaled today, as you heard there, they would intervene if the case makes its way to the Supreme Court. Let's bring back the front bench to unpack that. Christy Clark, John Tory, and Tom Mulcair are here. Tom, I'll start with you. I thought what was particularly consequential in this decision, and you would know better than me, but is that the court essentially ruled the invocation of the notwithstanding clause in the fashion that it was invoked was okay, was constitutional. How do you anticipate that plays out?
Well, it's going to be very tricky for Mr. Trudeau politically, and I'll get to that in a second. But to the core issue in the case was whether or not you could just preemptively use the notwithstanding clause to exclude all sorts of provisions that are discriminatory. The first instance judge in the Quebec Superior Court said the law is clearly discriminatory, but it's saved by the notwithstanding clause, except for one part that had to do with the English school boards that he said had constitutional protection under Section 23 of the Charter. Now, with regard to the larger issue, what it means politically, for Mr. Trudeau, he's been dithering. His procrastination could cost him dearly because for years now, people are saying, why are you forcing these groups, especially of Muslim women? Because there's a whole chapter in Bill 21-8 that can only apply to Muslim women. So you're not allowed to be hired as a teacher if you wear a headscarf, a hijab. So this is something that's been contested. Yeah, and so this is something that's been contested by these groups. They've been forced to take years to get here, where Trudeau had the power to refer directly to the Supreme Court. So that's always been an issue. And the other thing that Quebecers notice is that when Doug Ford even muses about using the notwithstanding clause, Trudeau's on it right away. Same thing. You're talking about gender issues, whether it's Saskatchewan or Alberta, on it right away. But he did nothing to defend rights in Quebec, and people have taken notice of that. He might regret it, because by the time this thing does get to the Supreme Court, as of course it will, the hearing could come right in the middle of the next campaign, and he might pay a heavy political price for his failure to stand up on principle in Quebec against Legault, the same way he does it against Doug Ford or other premiers in the rest of Canada.
It will be interesting, John, if it does go to the Supreme Court, to not just see the way in which it ends up focusing the federal government's response, but other federal political parties, too. I remember covering the 2019 election. This was a huge issue because nobody wanted to take a position on it at all because of how popular it was in Quebec at the time, how popular the provincial government there was at the time. It's less so now. And the impact on their electoral prospects because of that. Do you think that will change at all? Or is everyone kind of still afraid to offend Quebec?
Well, no, I think the answer is yes, they are. And I guess it's for obvious, quote unquote, political reasons. But I think it's not as much of a legal mess. And I would say I had a chance to read the summary of the judgment today, and Tom was just making reference to this. I mean, the fact is the notwithstanding clause is not going to change. It's there. The court has looked at it. It was invoked very, I guess, smartly by Premier Legault in advance, because he knew it would essentially take the fundamental issue off the table. And you see the judge saying we can't rule on the issue of freedom of religion and so on here because the notwithstanding clause has been invoked, and that nothing between now and the Supreme Court is going to change in that regard. And so I think it just becomes politically, very messy for everybody. Messy in the sense that I think when Premier Legault refers to a consensus, there's a pretty broad consensus across the rest of the country. This is not right. This is not the Canadian way we view people's ability to exercise their freedom of religion. So I think there's a lot of people that are not part of that consensus, but the notwithstanding clause stands in the way of any different result, and the politicians are still going to have to stand up and be counted on it.
Over the last few months, though, I have noticed, Christy, that the federal government, first Justice Minister David Lametti, now Minister Virani, they're weighing in a little bit more to the notwithstanding stuff because they seem to be, as Tom pointed out, especially when it was invoked by other provinces, upset at the idea it can be invoked in advance. What kind of a legal fight do you anticipate that ends up being if the feds actually do intervene if this thing goes to the Supreme Court on that basis?
Well, I think if the issue is whether or not provinces can use the notwithstanding clause, and that's what the court is ruling on, I don't know how the Supreme Court can argue against it. I mean, remember, Vassy, Canada was created as a group of provinces that came together under the BNA Act, recognizing that each province is distinct and different from one another. Now, there's no province more distinct than Quebec, but British Columbia is pretty different too. We would not have a Charter of Rights and Freedoms, and Canada's Constitution would not have been repatriated by Pierre Trudeau if the notwithstanding clause hadn't been in there. It's there to protect provinces' distinct identities and allow them to be able to, rather than have the federal government Bigfoot on everything they feel like stepping into, and this is a particularly sensitive issue, but there's tons of areas where they can do this to diminish provinces' ability to be able to manage their own jurisdictions. In order to stop that, provinces have the right to use the notwithstanding clause. There is nothing wrong with having that in our Constitution. In fact, it's a fundamental recognition of how Canada needs to work. So if this goes to the Supreme Court, my presumption is the Supreme Court will rule in favor of Quebec on it because they have the right to use it. That's entrenched in the Constitution for a reason. It's the only reason we currently have a Charter of Rights and Freedoms in the first place, and the federal government should start respecting that.
Just got 20 seconds left. The difficulty in this is, especially with Bill 21, there are a lot of minority groups that feel the invocation of that trampled on their rights. I mean, that's not a legal argument. I'm not a lawyer, but that was the political part of this. Tom?
Yeah. Yes, and the first instance judge said it trampled on their rights. It was discriminatory. And Christy's right. Here, the judge simply said, we're not touching that. We're not going to give an opinion on that. It's protected by this shield. It's a nettlesome issue. It is one that has been in the Constitution since '82, but we're going to see whether or not their full-throated support is echoed by the Supreme Court, because they went so far as to say this isn't an attack on democracy and democratic rights, like minority rights. This is the defense of the sovereignty of the ultimate decision-making body, which is the elected officials in the legislature. Collective rights, individual rights. Big debate.
Big debate, age-old debate, and probably around for a while. Thank you so much. I appreciate the discussion this evening. Thanks to our front bench, John Tory, Tom Mulcair, and Christy Clark.